5 seconds to go. Start. It is true that the accused tried to create a smoke screen with respect to his age, but such efforts appear to have been made only to hide his real age and not to create any doubt in our mind. The judicial system cannot be allowed to be taken to ransom by having resort to imaginative and concocted grounds by taking advantage of loose sentences appearing in the evidence of some of the witnesses, particularly at the stage of special leave petition. The law insists on finality of judgments and is more concerned with the strengthening of the judicial system. The courts are enjoined upon to perform their duties with the object of strengthening the confidence of the common man in the institution entrusted with the administration of justice. Any effort which weakens the system and shakes the faith of the common man in the justice dispensation system has to be discouraged. The above noted observations in Ramdev Chauhan alias Rajnath Supra no doubt were recorded by the learned judges of this court while considering the imposition of death sentence on the accused who claimed to be a juvenile. Nevertheless, the views expressed therein clearly lend weight for resolving an issue where the court is not in a position to clearly draw an inference wherein an attempt is made by the accused or his guardian claiming benefit available to a juvenile, which may be an effort to extract sympathy and impress upon the court for a lenient treatment towards the so called juvenile accused, who in fact was a major on the date of incident. Similarly, if the conduct of an accused or the method and manner of commission of the offence indicates an evil and a well planned design of the accused committing the offence, which indicates more towards the matured skill of an accused than that of an innocent child, then, in the absence of reliable documentary evidence in support of the age of the accused, medical evidence indicating that the accused was a major cannot be allowed to be ignored, taking shelter of the principle of benevolent legislation like the Juvenile Justice Act, subverting the course of justice as statutory protection of the Juvenile Justice Act is meant for minors who are innocent lawbreakers and not the accused of matured mind who use the plea of minority as a ploy or shield to protect himself from the sentence of the offence committed by him. The benefit of benevolent legislation under the Juvenile Justice Act obviously will offer protection to a genuine child, accused juvenile, who does not put the court into any dilemma as to whether he is a juvenile or not by adducing evidence in support of his plea of minority, but in absence of the same, reliance placed merely on shaky evidence like the school admission register, which is not proved, or oral evidence based on conjectures leading to further ambiguity, cannot be relied upon in preference to the medical evidence for assessing the age of the accused. While considering the relevance and value of the medical evidence, the doctor's estimation of age, although is not a sturdy substance for proof, as it is only an opinion, such opinion based on scientific medical tests like ossification and radiological examination will have to be treated as strong evidence having corroborative value while determining the age of the alleged juvenile accused. The learned judges have added an insight for determination of this issue when they recorded as follows. Of course, the doctor's estimate of age is not a sturdy substitute for proof as it is only his opinion. But such opinion of an expert cannot be sidelined in the realm where the court gropes in the dark to find out what would possibly have been the age of a citizen for the purpose of affording him a constitutional protection. In the absence of all other acceptable materials, if such opinion points to a reasonable possibility, regarding the range of his age, it has certainly to be considered. The situation, however, would be different if the academic records are alleged to have been withheld deliberately to hide the age of the alleged juvenile and the authenticity of the medical evidence is under challenge at the instance of the prosecution. In that event, whether the medical evidence should be relied upon or not will obviously depend on the value of the evidence led by the contesting parties. In view of the aforesaid discussion and analysis, based on the prevailing facts and circumstances of the case, we are of the view that Respondent 2 Vijay Kumar and his father have failed to prove that Respondent 2 was a minor at the time of commission of offence and hence could not have been granted the benefit of the Juvenile Justice Act, which undoubtedly is a benevolent legislation but cannot be allowed to be availed of by an accused who has taken the plea of juvenility merely as an effort to hide his real age so as to create a doubt in the mind of the courts below, who thought it appropriate to grant him the benefit of a juvenile merely by adopting the principle of benevolent legislation, but missing its vital implication that although the Juvenile Justice Act by itself. Stop.